On this episode of the show, we're going to talk about why you don't want to give your IRA away in your will. Creating wealth, protecting families, building legacy. This is the Rich Life Lawyer Show. Hey everybody, this is Christopher Small, and this is episode 70 of the Rich Life Lawyer Show. I am your host. I'm the owner of CMS Law Firm. I'm an estate planning attorney, and I'm excited to be here with you today talking about how to distribute your IRA when you pass away. A lot of us, many people, and I bet if you are watching this video, then you are one of them, have a tremendous amount of wealth wrapped up in an IRA. We're taught from a young age, max out your 401k, put everything into your IRA, blah, 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 do all this stuff. And so as you begin to think about your estate planning in your needs, you may be wondering if either giving away your IRA via a will or via beneficiary designation, so just designating someone to take over the IRA when you pass, is a good idea. And it's a bad idea for a couple different reasons. Reason number one, the main reason, is that you really give up control over how the IRA is going to be used once it is given to the beneficiary that you designate on your IRA. And this is a problem because if they don't do the right thing, or if they get a little greedy, they could eliminate a substantial chunk of all of that hard-earned money that you created. And they can eliminate a huge chunk of potential money into the future. Here's why. Let's say you have a kid, and this kid is 30 when you pass away. And the kid, and your spouse has passed away, everybody's passed away. Your kid is the beneficiary designated on your IRA. So if that's the case, then the IRA is transferred over to them. They can now do whatever they want with it. They have a couple of things that they have to do. A, they have to decide if they want to take the required minimum distributions, which means they can stretch out the distributions all the way to the end, just like you would have with your own retirement. They can decide to liquidate everything within 5 years, or they can do nothing, and they can pay penalties on the money that they should have taken out. All right. Within that time, though, at any time, they can cash out the whole thing. They can take the whole thing out and just take all the money. Here's the problem. If they do that, they're going to have to pay income tax on whatever that number is that they've taken out. And if it's over 100 grand, then we're talking about a 38%, or at the time of this recording or so, income tax bill. So if you take out 100 grand, that means you're only going to be getting $62,000 of that 100. Basically, they just lopped off a third. It's going to the government. It's wasted money. If they would have taken the distribution over time, yeah, they're getting less up front, but that money gets to continue to grow and grow and grow. And if you leave it in there forever, it's going to be huge by the time they're done. So basically, your hard work in the funding of your own retirement could fund the retirement of your kids in the future, very, very easily and simply. So the way that you can manage this, the way that you can make sure that this is done correctly, is to create a trust and then make the trust the beneficiary of your IRA. That way you can restrict the way that money is distributed. You can restrict and make sure that it's not taken out for bad things, parties, drugs, gambling, fun, whatever. And you can ensure that the IRA is stretched as far as it can, which means you get the maximum use and maximum benefit out of your hard-earned money. So hopefully that provides a little bit of guidance. If you want to know more, you can always call me, 206-659-1512. Email me, chris@cmslawfirm.com. I would love to speak with you more about this, answer any questions that you have, and help you make the decision that's right for you, because that's what matters. Okay? Take care, and thank you for your time.